This video is designed to help people understand how the Kansas Drug Registry requirement removal process occurs. Those who are affected are only those who are required by a court to register following conviction of a drug offense. Kansas maintains three types of offender registries, three types of criminal convictions that require registration as part of the punishment. One of those is the drug registry. Others are maintained for violent offenders, and a third for people who have been convicted of certain sex crimes. This new law applies only to people who are required to register due to a conviction of certain drug offenses. This new law includes people who were ordered by the judge as part of a drug-related sentence to register quarterly. It applies to people who are required to register either for 15 years or for lifetime periods of registration. For those who might be watching this and aren't familiar with this process, a bit of reality for those who are on the who have a drug registry requirement. This involves an in-person appearance at a particular place in the county where a person lives, works, or goes to school. In fact, it could require registration in 3 different counties at the same time, and the payment of a $20 quarterly registration fee in each place a person is required to register. It can also require prompt notification of that office of any change of address, workplace, new automobile, or new social media account. Registration requirements, even a few days late, failing to meet them can result in a severity level 6 person felony. That means, depending on the requirement, the criminal history, it could include a minimum 36-month period of incarceration, and sometimes much longer than 10 years of incarceration for simply failing to meet this registration requirement. This can sometimes be longer than the possible sentence on the original crime. So people who are eligible to end the registration requirement should consider asking a court to do that. It lessens the possibility of other serious charges in the future. There are a number of requirements that come into play about who is eligible to register. But the first one is that people have to be ordered to register only on the drug offender registry. The second criteria is that there must have been 5 years of compliance with the registration laws after the end of probation, parole, or any other post-release requirement. Since periods of incarceration don't require registration, anytime a person is incarcerated doesn't count and can't be included in that 5-year time period. One way to look at this is that the registration requirement requires a minimum of 20 visits to the registration office once every quarter or 4 times a year to meet this requirement. This 5-year compliance period applies regardless of whether the requirement is for a 15-year registration or a lifetime registration. In addition, other arrests and convictions may affect the period of registration. A person cannot have been convicted of a felony in the 5 years prior to seeking removal from the registration requirement, plus no felony charges can be in effect at the time, be pending at the time the person seeks to have the requirement met. So the new law, which is at KSA 224908, can is the law that allows people to seek removal from the drug registration requirement of a conviction. Before a person considers applying for this, there are a few things that should happen. One is to check the offender registry to make sure of two things. One, that it shows that the registration is only for drug offenses. And secondly, that it shows that the person is in compliance at that point in time. There's no way through the registry to confirm the 5 years of compliance, although the people at the registration office should be able to help with that. That registry can be found at Kansas Public Offender Registry. A search of that term will get people to the registry, and then people can be looked up by their name. It's also important to gather the $179 in court filing fees, or be prepared to seek a waiver of the filing fee if the financial condition of the person does not allow them to pay the court filing fee. And finally, as we'll cover at the end of this, consideration should be given to whether a person should seek expungement or the public sealing of their criminal conviction at the same time they are asking for relief from the registration. Process is very similar, and we'll cover that in more detail in a bit. The process for doing this involves a person seeking removal from the registry has to ask the sentencing court to end that requirement. There's a form for doing this, and we'll have links at the end of this. The process is something that a self-represented person can do. A lawyer is not required to do this or to file the paperwork. It's important to involve both the prosecutor, the district or county attorney in this process, because their agreement can mean that the process is handled much more streamlined and quickly. Because the prosecutor and the judge know little about you at this point in time and about your situation, except what they find in their criminal database, it's important to provide them with more information about your current circumstances. For example, you might get information from other people, a coworker, an employer, a boss, a probation officer. People who know your current situation can help the prosecutor and the judge know about your circumstances now, and that your treatment history demonstrates that rehabilitation has occurred and that lifting the requirement of registration is in the public interest. There is some information that will be required in the petition that you file. First of all, all the treatment programs and providers that you have attended, whether those were successful or not. You're going to need to list the name of the program or the agency where that happened accurately on the petition to the judge. You're also going to be asked to write a paragraph about your current circumstances. This is your chance to tell the judge what things have changed in your life during the 5 years that you've been registered. Are you working? How are you supporting yourself? Do you support other people? Has the registration requirement kept you from doing a kind of work that you want to pursue? Be aware, however, that the information you put in there will be public record because it's part of a criminal file. So you may want to be cautious about what you include. Once you have completed the petition, you will file it. with the clerk of the district court. It will be filed in the same criminal case in which your case in which your the registration requirement happens. That's going to start a review process. You should get a copy of the petition and also take an order that you've prepared removing you from the registration, again, available in the forms, to the prosecutor as soon as you file it. They will begin a review process that doesn't necessarily have a deadline. They're going to look at their criminal records database for your compliance with registration and any other charges or arrests that have occurred. Then they're going to make a decision about whether they agree with your request to be removed from registration. Many prosecutors welcome this law and are happy to remove people who meet the requirements from registering. So should not fear that the prosecutor is going to deny this unnecessarily. If the prosecutor agrees, they will sign off on your order and give it back to you. You could then ask that the judge, you will sign the order at that point at the bottom, and then can approach the judge to seek their approval. The judge may require a hearing, but is not required to. You would approach the judge by making an appointment with the judge through their assistant. This is another time for taking those letters that you've acquired from the employer, family members, treatment providers, probation officers for the judge to see as well. You might be requested to leave those things behind for the judge to consider and review and possibly sign. If the prosecutor doesn't agree to sign the form, it's still possible to ask for a hearing where you and the prosecutor will approach the judge about the registration. Because this is a new process, you may find that judges are more willing initially to allow this than the prosecutor is, and so having a hearing before the judge should not be considered a negative idea. They simply the prosecutor may be afraid of public pressure that could result from removing anyone from the registration early. So you have the choice of asking for a hearing and convincing the judge to remove you. The prosecutor will be present at that hearing and may, even at that late date, agree to it after hearing your time, or may state reasons for the judge why they don't think that you should be removed from the registry. If the prosecutor has reasons they don't think you qualify for removal, then you should work to overcome those as things go forward. You may be requested to fill out a notice of hearing and file it with the court once file it with the clerk once a date is set. That's going to need to be a date that's agreed to by the judge and the prosecutor. And then at that hearing, you should take a completed order of relief of registration and explain to the judge why you believe you meet the criteria and why you are asking the judge to remove you from registration. Particularly at that point, you may find that things that have happened while you've been on the registration are things that are important for the judge to hear. Once the judge signs the order, and we're approaching this with confidence that the judge will sign it, either because of an agreement or because you've convinced them in court, you should take that signed order to the clerk of the district court in that county to file. They're going to need also an order for relief from registration cover sheet. The clerk will file the order and will send it to the KBI. the Kansas Bureau of Investigation. That's going to start a process with the KBI to remove you from the registry, and they will send out notice that you're no longer required to register. They're going to send it to the county. They're also going to send you a letter. Until you have that letter from the KBI, you need to continue to register. If you've waited more than a month for that letter, you should contact again the clerk of the district court to be certain that the order was sent to the KBI, and that and you may want to contact the KBI to be certain that they received it. Having the date they were sent the order by the clerk of the court can help you track it down. You'll want to contact the KBI records department in Topeka at that point, but don't consider doing that until a month has passed since the order has been filed with the clerk. So I said earlier that one of the things you should think about is whether you want to file for expungement at the same time you file for relief from registration. The requirement for relief of registration and expungement are nearly the same 5 years after the end of probation or parole. The expungement requirement is a bit, and that is for serious felonies. The requirement about other convictions is a bit easier for expungement, but certainly if you meet it for expungement, you meet it for the registration relief, then you meet it for expungement. A chart here helps you understand who might be eligible for expungement. There are some kinds of cases that are not eligible for expungement. This chart shows the passage of time, talks about circumstances and behavior warrant expungement, and expungement is consistent with public welfare. So might look at that chart and see if you're eligible for expungement of the conviction, and then make the decision that you want to file either separately or in a combined manner. One of the advantages of the combined manner is that there is a $197 filing fee, and you can pay it only once for expungement and drug registry removal if you choose. The Kansas Judicial Council makes forms available for drug registry removal only, and that is available at the link here. You can go to Kansas Judicial Council, look at forms, and there is a set of forms marked adult expungement that includes also the the drug offender registration. So you can find that there. If you're looking for and you want to do the combined expungement and drug registry, then that form is available on the Kansas Legal Services website, which is just below where this video is posted. So you can find the form there. I just want to reiterate in closing to say again that the process should be one of filling out the paperwork, getting it to the clerk, helping the prosecutor see that you're a different person than you were when you were convicted of the crime, that you've complied, and that relief from that registration requirement would be helpful to you and also to not in the public interest. Kansas is the only state in the country that has a drug offender registration. It has been around for nearly 20 years now. People are just beginning to roll off of it because they've done the entire 15 years. But it is something that people can and should consider doing the requirement is difficult for people to meet, and for those people who have changed and deserve a second chance, this is one way of getting it. I hope this video is helpful, and you consider seeking removal of the drug offender registration requirement if you are eligible. Thank you.